Good morning, everybody. I'm Jane Fielding, and I am head of the Employment, Labour and Equalities team here at Gowling WLG in the UK. And I'm delighted to welcome you to the first in our series of annual update webinars, where we cover topics which we think you need to know about heading into 2023. We did contemplate going back to doing these sessions in live in person, but with the triple whammy of rail strikes, freezing temperatures and various lurgies, we decided to stick to the tech format of webinars. But we will be going back to in-person in summer when we do our mid-year reviews, and we hope that we'll be able to welcome all of you on our balconies in our offices and enjoy some summer sunshine. But for now, we are doing our first webinar, and the first session, as you can see, is about artificial intelligence, AI. And it's really a myth-busting session about AI in the workplace, how it's used and how it fits with our current employment laws in the UK. And I can't think of anybody better placed to talk to you about this topic today than my friend and partner in the team, Jonathan Chamberlain. And that's for three reasons. Firstly, in the 20 years I've known him, he's always been an early adopter of tech, dragging me with him with varying degrees of reluctance, depending on what the tech is. Secondly, and most importantly, he has recently been on the Employment Lawyers Association Working Party, which was responding to a call for evidence from the House of Commons Science and Technology Committee about the use of AI. So he's absolutely bang up to date with the debate in this area and how it fits with our laws. And lastly, and most frivolously probably, I would defy any AI programming team out there dialing in to produce AI that can match Jonathan's energy and enthusiasm for this topic, as you'll see. So he's going to present enthusiastically for 35 minutes. I will keep an eye on the questions as we go along, and I'm probably going to interrupt Jonathan with yours and some of my own, and any that are left over we'll sweep up at the end. If you want to ask a question, please can you use the Q&A function in the middle of the bottom of your screen, rather than the chat function, which has been disabled. And please do put your name on the question. That's not so we're going to name you in the webinar, but if we don't get to your question, we want to be able to come back to you afterwards. And that's obviously slightly tricky if you haven't put your name on there. We hope the tech all works, particularly on this of all subjects, but if it doesn't, please can you also use the Q&A function, and Lucy Strong, who's helping behind the scenes support us on this, will come back to you and hopefully sort out whatever issue it is for you. I will make sure that we finish at 11:45, which is what we've promised you, and we'll be sending a short email questionnaire after the webinar for those of you who've attended for the full, so that you can give us your feedback and we can use that to help shape future sessions. I'll remind you about that at the end as well. But that's all from me for now, and I will hand over to Jonathan.
Jane, thank you very much indeed. Well, good morning. I'm talking to you about artificial intelligence in the field of employment this morning because I was, and I still am, rather wary of it. Now, don't get me wrong, I know, well, I believe that we're not going to need Arnold Schwarzenegger to come back from the future as a robot to protect the young Jack Connor so that he can in the future defeat the machines which have taken over as a result of artificial intelligence. Okay, I'm not that scared yet, but I did understand that here was a technology which I didn't understand, that was clearly very powerful, that everyone said is going to impact the world of work, impact what I do, impact the law on which I advise. And as I say, I knew I didn't understand it. So part of the work that I did in chairing the committee that Jane has just referred to, the Employment Lawyers Association Working Party responding to the House of Commons Science and Technology Committee's call for evidence on the governance of AI. Here's our report, by the way, I'll be referring to that later, was so that I could get to grips with it and then explain it to you. And I think the key thing that I've learned is this. It helps me to understand AI, to accept that I don't understand AI. Now, that may seem a bit Delphic, may seem like your therapist talking, it may seem like a complete load of rubbish. Can I ask you please to bear with me? All will become clear as we go through this, but the key to understanding AI is to accept that we don't understand AI. So here's our agenda. What is artificial intelligence? Good place to start. What can it do in the workplace? What are the issues with it? And what should you be doing about it now? So we don't need the agenda slide anymore. That's the last slide that we're going to have. If we get a comment in the Q&A saying, I can't see the slides, it's because there aren't any slides. That was it. That was the only one. But I shall signpost as we go through. And my first bit of signposting is we're going to start with my first bullet point, which is what is AI? And here's the thing. There's no obvious or easy answer. There is actually no generally accepted definition of AI. There isn't one in law. There isn't even one amongst the scientists and the technologists. Perhaps the earliest was the famous Turing test. Can a man have a conversation with a computer and not know that it's a computer? But there have been plenty of others. We referred to some of them in the report, because obviously if you're doing a report on the governance of AI, it sort of helps to know what AI is. So we have this from the AI pioneer and scientist John McCarthy. This is back in 2004. He suggests it is the science and engineering of making intelligent machines, especially intelligent computer programs. It is related to the similar task of using computers to understand human intelligence, but AI does not have to confine itself to methods that are biologically observable. Well, I hope that's clear. IBM, here we are, the IBM factor. Through the use of statistical methods, algorithms are trained to make classifications or predictions, uncovering key insights within data, gradually improving its accuracy. I quite like that one for reasons I'll come back to. The TUC, as you might imagine, are typically blunt. Unfortunately, there is no single agreed definition of AI, algorithm, or machine learning. And they then adopted different definitions. Artificial intelligence means when computers carry out tasks that you'd normally expect to be carried out by humans, for example, making decisions or recognizing objects, speeches, or sounds. Machine learning, come back to machine learning, means when computer programs are trained on data so that the program can learn to carry out certain tasks. Trained on data, program can learn. And an algorithm used in technology is often a set of rules that a computer applies to make a decision. Now, does it completely matter that we don't have an agreed definition of AI? I don't think it does actually at the moment. I don't think it does because, as we'll see when we come on to this, our regulation, our law, is not actually focused on the technology. It's focused on the impacts of the technology. And I, for one thing, that has absolutely to be right. I don't really care what's happening in the black box. I care what it does to people. So we don't really need to concern ourselves about that. I will illustrate the difference in this next section, the difference between artificial intelligence and just, bog standard computering, if you like, in the next section when we come to talk about what IT or AI can do. And I would suggest in our arena, that of a workplace, perhaps there are 6 things which it can do. How well it can do them, how it does them, are different things we'll come on to. But these are the sort of things that is suggested that AI can do. There are 6. Firstly, it can read CVs, pick out key information. Obviously very helpful if you have thousands to look through, even hundreds in respect of a job application. Perhaps, and here's the second thing, it can go further. It can interview candidates. It can analyze a video recording, or it can interview using a chatbot where people put in responses. And it can analyze the results of that and help you as a recruitment tool. Analysis, help, different concepts, we'll come back to those. Now we've used it as a chatbot in recruitment, perhaps we can use it, and this is the third point, as a chatbot in HR support. I think this is probably quite common already, actually. You program in, you write in, how much holiday have I got left? And the chatbot will tell you. It will help with basic information about policies and processes, and it will be able to make sense of what people type in. That's the AI bit. Fourth thing, it can look at people's performance, look at where they are in their career, and suggest appropriate training to help them develop. That puts it in quite a positive light. What about perhaps putting it in a bit more threatening way? And this is the fifth point from the point of view of the employee. The AI can give instructions. It can tell you what to do. I'm aware that there are technologies for use in call centers which not only monitor employees' voices, that's happened for a long time, but now monitor eye movements. So they can tell when you're looking at the screen or not, and they can bring you back in the room. And let's take this a step further for perhaps the sixth use. What about work allocation? Telling you what you have to do when, and if you don't do what you have to do when, imposing sanctions of some sort. Now that already happens outside of the workplace, and I'll give you an example of that in just a second. Perhaps it happens within the workplace. So that's what it can do, we're told. They're the six things that I talked about: reading CVs, doing an interview or chatbot support, monitoring output with a view to improving training, giving instructions, allocating work, and imposing sanctions for failure to do it. There are two things, though, that I'd really like you to take away in relation to that list. And my first one, I'll illustrate by way of example, because artificial intelligence, as we saw, it has no definition. And as I explained to you at the beginning, it's something I'm quite wary of because I don't understand it. I keep coming back to this point. To understand AI, accept that you don't understand it. And one of the things about it is that it's quite frightening. And it's quite frightening because we don't understand it. And people slap the label on because it's something they don't like. So let me give you a really good example of this. And this example is actually captured on video. You can go on YouTube and watch this. If you search for Politics Joe UK, you will see this. It's a House of Commons Select Committee interviewing the European Head of Public Relations for a very large shopping website. Okay, and this hapless individual is pulled apart in a really good piece of cross-examination by the MP, first rate. And what it was about was the MP said one of his constituents worked in one of their warehouses and he had a wristband. And the wristband monitored his movements around the facility. And if the computer thought he wasn't doing things quickly enough, he got a warning. And if he got 3 warnings, he was out. And the cross-examination was about whether this was in fact what the company did. And the manager didn't handle it well at all. I think all you would have handled it a lot better, actually, because you're not in PR, you're in HR or legal, and you would have got to the answer straight away. But anyway, he handles it very badly. And people talk about this as an example of artificial intelligence in the workplace. But actually, from the clip, I'm not sure it was at all. I'm not sure it was any different from the old time and motion studies. From the chat, usually was a chap, in a white coat with a clipboard and a pen and a stopwatch, monitoring what you do in order to improve processes. And in this particular case, this is a time and motion study carried out by a computer using a wristband. But that's actually all it is. And that the parameters have been set as you have to do this within a certain amount of time. And if you don't, then this process follows. But that's not AI as such. It is use of technology. It is intrusive. It brings up some of the same issues around AI. But fundamentally, it's an old-fashioned time and motion study using new technology. Contrast that with, say, a global ride-sharing app, whereby you can input on your phone and a car will come and whisk you away to wherever you want to go. Now, as far as you're concerned, you're placing an order through the phone. What about the driver? When the computer has a choice of 2 drivers, 3 drivers, 4, half a dozen, 27 if you're in central London, who could fulfill your order on the phone, which driver does it choose? Well, we don't know. We certainly don't know as the customer, but the driver doesn't know either. The computer will analyze all the data it holds about the drivers in the area, where they are, where the destination is, what the weather is, what the traffic is like, what that driver's record is like, what their customer ratings are like, and other bits of data that is monitored and picked up that I don't even know what it is. And it will have analyzed the performance of the thousands of drivers on the hundreds of thousands of rides that have taken place. And it will calculate, I'm not going to give this ride to Joan, I'm going to give it to Fred. Neither Joan nor Fred know why it's taken this decision. Heck, the manager, the guy who turns the computer on in the morning, doesn't know why the computer has taken that decision, because the computer has learned itself from all the data that's in there what it thinks is going to be the best outcome that will generate more profit for the ride-sharing app. Now, that's artificial intelligence. That's machine learning. That is the computer making up its own mind. And I see that, that's my working definition of the two. And that brings me to my second point, which I really want to stress around what can AI do, which is this: beware snake oil. Okay, there is a huge amount of snake oil around AI. So let me take you back to the examples that I gave in terms of AI can conduct an interview in the workplace. Well, because it can look at videos. Well, just think about that for a moment. So can a computer really analyze a video and decide that this person is the best candidate for your job because of what you see on a camera? Have these people ever heard of acting? Or in relation, you'll see that the snake oil salespeople, and there are a lot of these, will say, oh, we can look at body language, we can see how people present, we can understand the key words that they use, and we'll be able to work out who's the best candidate, who's the best pool of candidates for you. Well, if you think about that for a moment, stand back from that for a moment, that is nonsense. There is no body of research which says that that can be done, let alone that a computer can do it. And I don't think it's any coincidence that a lot of these things come from the US, where, for example, they still believe, despite all the scientific evidence to the contrary, and it is all the scientific evidence, that lie detectors are a thing. Lie detectors are not a thing. You can train how you respond to a lie detector, and it has a huge margin of error in any event. And similarly, with this so-called interviewing software, it can be gamed relatively simply.
Jonathan, I was just going to ask a question about the ride-sharing app, but it also, I think, is relevant to the recruitment decisions, how does, to the extent these things exist already, how do they factor in the obligation under the Equality Act to make reasonable adjustments? So somebody may not be hitting the criteria that the artificial intelligence is looking for in an interview, for example, or in the drive hailing, they might have a poor record of attendance due to disability. Is it sophisticated enough to take that into account, or how does that work?
It could be sophisticated enough to take that into account to a certain extent. Whether it is or not is going to vary from program to program. And one of the things that we're going to come on to in terms of practical things which you should be doing now is due diligence and asking all those sorts of questions. And if I could just give you a rule of thumb, which I was going to do later, but it's relevant to bring it up now. Salespeople for American products will tell you that these have been vetted for all equality laws. They may well have been vetted for all American equality laws. It is highly unlikely they will have been vetted for the UK ones, especially if they don't originate in the UK. So the PR guy who I referred to earlier, judging from his accent on the film, and that's all I know about him, is from the US. So you and I are looking at that video, actually screaming reasonable adjustments at him as he's talking about this, that the MP is talking about this 63-year-old who isn't necessarily making things in time, and we're screaming age discrimination. And it was, if he did have those concepts in his head, he couldn't access them as quickly as you or I would have accessed them, put it that way. And I think that runs through in the software. Salespeople are very optimistic about the capabilities of this stuff, and AI can be gamed. My favorite example is actually not a human resources one; it's a military one. GuardBot. Okay, you've got a computer with a machine gun which is guarding a facility. This has happened. Okay, this has happened, and it has been programmed to distinguish between friend and foe, and it will learn from who approaches it, who's friend and foe. Not great if it makes a mistake, but anyway, you know, that's what it does. And all it took was a squad of US Marines who worked out very quickly that if they approach this in a big cardboard box, a couple of them, then the AI wouldn't be able to recognize that they were in fact a human underneath the cardboard box, and so would let them through. So, you know, there is a lot of snake oil out there. Be careful of it for exactly the reasons that Jane has just highlighted. And this brings me on neatly to my third point of the four that I highlighted. We've discussed what is AI, we've discussed what can it do, and I've told you what can it do to beware of snake oil, primary point. What are the issues around it? And I've got 3 points that I want to talk about. And of course, as Jane has already highlighted, discrimination, potential discrimination, is one of those issues. Actually, before I make the 3 points, I want to highlight what I see as the fundamental problem in the workplace of AI as it relates to employment law, which is this. We say that a relationship of trust and confidence is necessary between employer and employee. It's a fundamental tenet of the employment relationship, the duty of good faith, as it's sometimes called, but actually expressed as a necessary relationship of trust and confidence, which neither party must do anything which tends to undermine. Okay? So let me ask you this. How can you trust, how can you have confidence in a machine where you don't understand at all why that machine is taking decisions about you? How can you trust it? I mean, you can say, just don't worry, trust the company, but that's not trust. That's faith. Okay. That's not the same as a very human concept of trust and confidence. So conceptually, if you leave too much to the machine, you undermine the whole nature of the employment relationship. Now, that's not an insurmountable obstacle to using AI at all, as we will come back to. But I go back to something that I said at the beginning. For me, the key to understanding AI is to accept that I don't understand AI. I don't know what this stuff does. And I have to mitigate the effects of me not knowing what this stuff does. So, for example, the three things that I want to talk about are data protection, the information imbalance as far as employees are concerned, and then the discrimination point that Jane's already highlighted. So the first point is data protection. Well, of course, as you would expect, this is about processing of data, so the data processing rules apply, and you'll already be aware that within GDPR, there is a right in respect of automated data processing, which can't be done without the employee's consent, except where it's necessary for the performance of the employment contract. There's two things which have already been highlighted as a result of that. There aren't any cases on this at the moment, but cases on these will surely come. The first is necessity. Okay. We use necessity to process employee data all the time. We don't seek to rely on consent because, of course, consent in the employment relationship can't necessarily be said to be freely given. So we use necessity. But is it really necessary to use an automated data processing facility? Is it necessary to use AI, or is it merely convenient for the employer? So we're going to expect some cases around necessity, but then there's also one around automated, because one way of getting around the obligation to provide information if it's an automated process is to leave the final decision to a human, and then it isn't a fully automated process. Well, yeah, but if the human 9 times out of 10 is going to take the same decision, to what extent is that process not really automated? To what extent is putting a human in this just window dressing? And again, there's going to be case law around this in the near future. That I am as certain as I can be of anything. So if those are the individual issues on data protection which come up straight away, second point I wanted to make was on the information imbalance. And I go back to my not understanding point. If you're an employee and decisions are being taken about you and you don't understand them, it's making worse an already bad situation. None of us. I am a partner in a professional services firm. So I'm an owner of the business. Okay? I'm one of over 100 owners of the business, but I'm owner of the business. So if anyone should know what's going on, it's me. And let me tell you something, I haven't a Scooby. And I suspect that's true about most of my partners most of the time, because management does stuff, and we know that. And because of where we are, we sort of accept that and we let them get on with it. But it's not like that for everyone. It's generally speaking much worse. And that sense of a lack of agency. And that can have very important consequences. One of those consequences we will see in a moment when we come on to talk about discrimination. In fact, let's talk about discrimination now, and we'll talk about how we deal with the information imbalance and the effect of that on the employment relationship when I come on to tell you about things that I think you should be doing now. The discrimination point, I think, will be screaming out at you by now, just in the way that I'm screaming at the YouTube clip of the hapless manager on Politics, Joe. But let me give you an example. If you're using AI as a recruitment tool, the machine's going to have to learn what successful recruitment looks like. So the way that the machine might look at what successful recruitment looks like is, who are the people that you've had in post for 2 years, 3 years, 5 years, whatever, from their initial recruitment? Because if they're still there, then they are, it would seem to me, to be successful recruits. But what data is the machine going to learn about successful recruits, and how is it going to apply them? Go back to that ride sharing app. We haven't a clue as to why the computer is allocating the ride to one particular driver or not. And for the most part, we as the consumer don't care. But if you're an employee, then you care quite a lot. So again, let's go back to professional services, which I used an example a moment ago. You might conclude, if you were a computer looking at the a population of partners in professional services firms across the UK, that successful candidates were people who were white and male, because that's the information that you've got. Now, the issue that you have as a manager and as an employee is you don't actually know on what criteria the machine is making its decisions. And finding that out is really hard. You have to be able to have the skills to interrogate the machine. And we'll come back to the consequences of no, actually, let's deal with the consequences of that now. And when we were preparing for this was a question one of the first questions that Jane asked me, which is, okay, if I'm an employee and I want to sue my employer or would-be employer over a recruitment decision or promotion decision, whose fault is it? Is it the responsibility of the software? Is it the responsibility of the software provider? Is it the responsibility of the employer? Now, the answer in law at the moment is actually obvious. It's the employer. But if you're the employer, at that point, you might want some help from your software provider. And we'll come on to that in just a moment in terms of the things you should be doing now. So what are the things you should be doing now? This was my fourth point, you recall. And the first one is due diligence. Okay, I said to you there's a whole load of snake oil around. How do I know I am not being sold snake oil? Now, has this program been audited against UK equality law? If I am faced with a claim, will you indemnify me against the costs of that if it results from a decision taken from your software? And then the other questions you'd be then expecting to ask that follow from that: are you able to explain to me how this software works in terms that I can usefully understand? Are you going to be around? There's a lot of startups. Are you going to be around so that I can enforce the indemnity that I've just got from you? If somebody comes to you with an AI solution for your particular problem, you need to be pressing them really hard on this stuff. Okay, and don't assume that because lots of other people are using this, that they're onto something that you're not, that they've done the due diligence and you can rely on that. Some of the snake oil is much more widely accepted, particularly in the US, than really it should be.
I think that begs the question, Jonathan. Sorry, two questions. One is, when you do your due diligence, who should be involved in that? Because there's different factors for it, aren't there? It might sit with IT, but it really needs HR and legal input, I suspect. And the other point, as you were talking, you talk about indemnification. Well, that's fine for the financial award, but it's not going to help. You can't indemnify for your reputation, can you? If you're found to have discriminated.
You can't. You can't. And I think the decision to adopt AI should not be an easy one. Because it does carry quite a lot of risk. And if on a cost benefit analysis, the savings are marginal, query whether you should be doing it yet. Do you want to be an early adopter of this stuff, or do we need to wait until it's settled down a bit? I do know colleagues in in-house employment lawyers who work for very large employers are under huge pressure to sign off on AI contracts, because in terms of just recruitment, let alone ongoing monitoring, huge savings have been touted. And okay, understand that you don't understand this, and that therefore you need to get to grips as much as possible with what you don't know and bring in the right people to do that. So that's due diligence. What about the other things? Well, when we talked about governance of AI and what the law should be doing, we said there were 2 points, and yes, we think there should be some law on this, but actually the working party is composed of lawyers like us, who mainly act for you, employers. Also, we had on lawyers who worked for individuals, and we had representatives of trade unions there, and there was a consensus amongst all of us, which is the workforce as a whole need to understand this stuff, and individuals need to understand this stuff. So my next 2 points are about the provision of information and consultation. The unions are arguing that you have to consult about AI because of existing law, and some of us are pretty skeptical about that. But they do say that, you know, you can squeeze it in the health and safety consultations, because people will be dead stressed if they're managed by AI, and stress is a health and safety issue. Therefore, you should be talking to your health and safety reps about this. I can kind of see that, but I think it's a bit of a stretch at the moment. But that's where they're coming from. But in any event, good practice. Remember what I said about this is an existential threat to the employment relationship. Issues of trust and confidence. Win the trust, win the confidence of your workforce by explaining what this stuff is going to do. And then if it's going to affect individual people, consult with those individual people. And that goes back to the point, you remember I talked about the information imbalance. How do we address the information imbalance? This is how. Use your existing consultation forums if you have them. If not, think about setting them up. Again, remember, you should only be doing this if there are big wins involved for the organization. And if there are big wins, those big wins need to be supported by appropriate employee information and consultation processes, which may or may not be provided for in the law at the moment, but which I think you should be adopting as good practice. So those are the 4 points I wanted to cover. What is AI? No clear definition, but do we really need one at the moment? Probably not. What can it do? Well, it's advertised it can do lots of things, but beware of snake oil and understand what AI is and what it isn't. What are the issues? It's potentially existential as far as the employment relationship is concerned, but there are issues around data protection, around the imbalance of knowledge, and crucially around discrimination. What should you be doing in practice? Due diligence, and providing information to and consulting with your employees on a collective and an individual basis as you introduce this stuff, if you're to win the necessary confidence of the workforce and individuals within it. So we had a couple of questions whilst we were going on. We've still got, I think, just about 6 for any more that have come up, Jane.
Yeah. So there's one that goes back to the point we were talking about in terms of if you get any claims in a tribunal, you've done your due diligence, you hope on the way in somebody's signed off on buying it, obviously, and hopefully you've brought your workforce with you in general terms, but somebody claims, who is actually the witness? So even now without AI, sometimes we get managers reluctant to stand behind the decision they've taken. And obviously there are cases in whistleblowing where people have felt pressured to take a particular decision, and the controlling mind has fixed the organisation with liability. So in granular terms, if managers are saying, okay, well, you company have bought this AI, is it the individual manager who is overseeing that recruitment process who would be the witness? Is it the person who signed off on buying the thing? I mean, how does it all work out on the ground? Because for the in-house employment lawyers under pressure that you referred to, that is a very relevant consideration, isn't it?
It is. And of course, at this point, the in-house employment lawyer is going to be watching his colleagues running for cover, pointing their fingers in opposite directions. And this is a key point about accountability. The accountability will be with the line manager of the employee. And if the line manager says, well, it was the software that did it, the line manager is going to have to explain how it was they relied on, why it was they relied on that software. And they may need support from a technical colleague, they may need a support from another colleague in HR. But as ever, it will be if not the decision maker, because that was the machine, then the person in the org chart who is notionally identified as the decision maker.
Yeah.
In practice, I suspect it won't be that easy for precisely the reasons that we've just identified, which is if this goes wrong, success has many fathers, failure is an orphan, and no one is going to be wanting to take ownership of this. So I go back to my due diligence point. If you are an advisor involved in the purchasing of this software internally, then one way to concentrate people's minds will be, are you prepared to defend the decisions this software takes in an employment tribunal? Because if you're not, query if we should be buying this. Yeah.
There's another question, or I guess a comment framed as a question, but I think it's interesting to get your view on it, Jonathan. In light of everything you've said, should AI therefore be used just for quantitative matters, not qualitative? Maybe if it's just quantitative, it's not necessarily AI. I don't know, but what's your view on
it? It is AI because it depends what quantitative data you take into account. So for example, in the ride sharing app, you wouldn't necessarily ask the AI to take into account the weather, but the AI may have noticed a correlation between the weather and the performance of drivers in a particular location at a particular time, which is not a correlation which a human would have spotted, but the AI does because it's in the data, and that's quantitative. But there is a fundamental point about AI, which is that it actually isn't much use at measuring qualitative data. So lawyers will charge you literally for staring out of the window. I mean, whilst we're staring out of the window, we are thinking about your problem and the best way to solve it practically and how to deliver the advice. What it looks like we're doing is staring out the window. So how is the computer going to be able to measure that? And at the moment, no one knows.
No.
So I think the answer is that we are some way off a computer being able to do a qualitative analysis of human performance. Now, we are not very far off from computers being able to do a qualitative analysis of written data. And if I can give you an example of that, Gowling uses artificial intelligence to read leases, to extract from a lease, however written, important information about break terms, rent reviews, etc., and that is worth applying when you're buying a bulk property portfolio, an investment portfolio of hundreds, if not thousands of properties. And the AI does a better job than lawyers of reading through the leases, and it does it in a fraction of the time. Now you can see one day in our line of work in employment tribunals, AI being applied to all the written evidence in front of them, and in simple cases taking the decision itself. So I can see lawyers' jobs going that way, but I can't see AI taking over the management of lawyers, given all the variables of performance involved.
Yeah. Okay, thank you. I think we're nearly at 11:45, so we'll call a halt there on the questions. If we didn't get to your question, we will follow up with you. As I say, thank you for putting your names in there as requested. So we will be circulating the questionnaire by email shortly after the webinar. So do please fill that in if you can. But I think Jonathan has given us lots of food for thought, and I really do thank him for covering that topic for us so well. I hope you can all join us for our next webinar, which is this Thursday, where as a sort of natural evolution of this, or perhaps a deeper dive, we're going to be looking at data protection and things you need to be aware of, update on that area, which fits quite neatly with this one. So Thank you again to Jonathan, thank you to Lucy, and thank you to all of you for joining. Enjoy the rest of your day.